Mike Heim with the Reviser of Statutes Office. Mr. Chairman, members of the committee, this bill would ratify some proposed permanent administrative rules and regulations concerning sports wagering. There was a law passed in 2024 that requires the legislature to ratify rules and regulations that will have an impact of $1 million or more on economic impact on businesses and so on over a 5-year period. And this is the first bill that I've dealt with that actually requires the legislature to look at the rules and regs. I've got a copy of the rules and regs. I think you've got one on the S drive, and that's the bill. It basically ratifies the rules and regs that are listed in that paragraph.
Committee, any questions for Mike? Not seeing any. Thank you. Yes, pretty simple deal. They've been operating off of their temporary rules for the last several years, and they've recently just had them all codified, and everybody has gone through and certified it. So we are now moving to permanent rules and regs. But here to explain all that, James Bain is here. James, welcome to committee.
Good morning. Thank you, Chairman and the rest of the committee. As indicated by Mike and Chairman Kessler, it is a pretty straightforward bill. We're just here to ratify permanent regulations, so I don't want to repeat what's already been said, but I might take some time to talk about the history of the regulations and then get into the economic impact statement. And so when sports wagering was passed back in 2022, the Kansas Racing and Gaming Commission was tasked with writing rules and regulations. Through that process resulted in the temporary regulations that are in place today and have been in place since the launch of sports wagering back in 2022. The permanent regulations that are part of SB 502 are largely the same. There are a few changes, mostly the changes, Kansans that are currently wagering sports on the applications will not notice any of the changes. They're mostly administrative. And the operators will not have to change their operation based on the going from temporary to permanent. They're already operating under these regulations. And so now, as we've talked about and Mike mentioned, we're transitioning from temporary regulations to permanent, and that is what implicates the economic impact statement and the ratification when the cost to implement permanent regulations are over $1 million in 5 years, in the first 5 years of implementation. And so the costs in this bill really boil down to the mobile technology. The act of accepting a sports wager or making a sports wager is simple, except for the mobile application part of it. This would not be $1 million over 5 years to implement. If we were only talking about wagers made at a gaming facility, we would not be here needing ratification for the cost. The cost is all in the technology, the security, and it looks seamless to the average person that places a sports wager, but the technology behind it is complicated, and that's where the cost comes from. The cost is only borne by the operators, no cost to government, no cost to Kansans. And so I don't have much more to add. This bill passed the Senate 39-0. Did not seem very straightforward and non-controversial. With me today is Randy Evans from the Racing Gaming Commission as well, and we are ready to answer questions about the economic impact statement or any specific regulation you may have.
Committee, any questions? Representative McNorton.
Thank you, Mr. Chair. So does this affect any of the things we heard in the interim committee about the contracts that are coming due? Or is this anything to do with that?
Nope, this is solely on the regulation, the security, the suspicious behavior, the things that the Kansas Racing and Gaming Commission, the law enforcement side, the lottery handles the business side of gaming. Kansas Racing and Gaming Commission handles the law enforcement side. And so that is all that this gets into. A lot of consumer protection. It gets into how you're paid. If you win a wager on your mobile app or you have money on your mobile app, how you get paid. The security audits, you know, how they're protecting your information. And so we have a lot of that in here. But sports wagering will still be legal. If this does not pass, sports wagering was still legal in Kansas. We would just be operating under the temporary regulations, and when those run out, there just would be no regulation. But sports wagering would be legal still in Kansas.
Okay, thank you, Mr. Chair. Thank you for your answer.
Committee, any other questions? Representative Wagner.
Thank you, Mr. Chairman. Again, just to kind of follow up, just making sure I understand what we're doing. So some of the internal regulations, as far as like in some states, you know, you can't bet on college games, or certain kind of parlay things are not allowed, you know, and in Kansas they are. Is that part of this regulation, or that's a whole different set of regulations?
That's in the lotteries regulations and under the lotteries purview.
Representative Howell.
Thank you, Mr. Chairman. How often do states typically have to reauthorize regulations, or is it just now, once it's permanent, then you would come to the legislature if you needed any regulatory approval for certain aspects of this?
So if we had to amend these, there is a process for amending regulations, and I don't think we would come back in front of the full legislature again unless we went over this $1 million threshold again. But there is an amendment process that comes before a committee, a legislative committee. So I don't know if that answers your question. If there were amendments needed to be made, we would not have to. Well, I guess, so in Kansas, we do have the process where we do have to review our regulations every 5 years. But unless there are amendments made, we would not come back.
Mr. Chairman, I have a follow-up. Have there been any enforcement actions taken under the temporary regulations?
So, not enforcement actions against the platforms. Our platforms are great. We do hear complaints, we do get reports of violations, we make a phone call and things get fixed very quickly. And so we have not had to take enforcement actions against the platforms.
Committee, any other questions? Not seeing any. Thank you, James.
Thank you.
And committee, that's all we actually had for this. We don't have any other testimony, neutral or opponents, or was there anybody else wanting to speak on this topic? Not seeing any. We're going to close the hearing on SB 502. We're going to open the hearing on SB 452, and Mike will get us started with that.
Mr. Chairman, members of the committee, this bill deals with law enforcement activities and federal law enforcement. The first section of the bill establishes a new crime, unlawful approach of a first responder, which basically approaching or remaining within 25 feet of an individual the person knows to be a first responder while that first responder is engaged in the performance of their duties, receiving a visual or audible signal not to approach within the 25 feet, and causing the first responder to be distracted, have an increased level of physical harm to any person or damage to property, and so forth. It's a Class B misdemeanor. Class B misdemeanor, the maximum jail time would be 6 months and up to a $1,000 fine. And the definition of law enforcement officer includes both state and federal law enforcement officers. Section 2 deals with abandoned vehicles on roads, and the amendment basically is on page 4. Whenever any motor vehicle has been unattended for more than 48 hours, or when unattended motor vehicle interferes with the public highway operations or any law enforcement operations, then it can be removed, and law enforcement officer is defined to be the state as well as the federal law enforcement. Authorized emergency vehicle statute in Chapter 8 is amended to include federal government vehicles. Section 4 deals with particular vehicles that have been designated by the Board of County Commissioners as an emergency vehicle. And there's an exception, certain vehicles, and included are those that are owned by the federal government as an exception. There is a definition on section 5 on page 5, dealing with the crime of interference with law enforcement officer to include federal law enforcement officer. The section 6 on page 7 deals with the crime of public interference with the conduct of public business in public buildings, and that includes the federal offices. And the section 7 deals with an amendment to the Kansas Tort Claims Act, which provides that a government entity or an employee within the state of Kansas, includes state and municipal employees, when they enforce or fail to enforce a law, whether valid or invalid, there is immunity from negligence anyway, and it would add any federal law or executive order. So if you've got questions, I will try and answer them. That exception for enforcement of a law, there's been probably a dozen or more appellate court cases, maybe 24 dealing with that particular immunity provision. I'll answer questions if I can.
Committee, do we have some questions for Mike? Representative Reese.
Thank you, Mr. Chairman, and thank you, Mike, for that brief on this bill. So you described an unlawful approach and what the penalties would be. What is a lawful approach under this bill?
Well, the unlawful approach would be if you get within 25 feet. That's if you're within 10 feet and they tell you to move back and you don't, then you violated this statute.
Okay, thank you, Mike.
All right.
Committee, any other questions for Mike? Not seeing any. Thank you, Mike. We're going to open up into the proponent side of this, and first up we have Ed Klump. Ed, welcome back to committee.
Thank you, Mr. Chairman, committee members. Ed Klump, I'm representing the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. I think I'd like to start out just telling you some things this bill does not do and some things the bill does overall before we get into the nuts and bolts of it. This bill does not grant any authority to law enforcement, to a federal law enforcement officer to enforce a state law. It grants no new authority to federal law enforcement officers. It does not grant authority to a Kansas law enforcement officer to enforce any federal laws. So none of that changes with this bill. What this bill does is it adds some provisions to the law to include federal law enforcement officers in certain statutes. And it's not just ICE officers. The more common ones we work with are the FBI, the U.S. Federal Marshal Service, ATF, DEA, Secret Service. It's all federal agencies that would be covered into this. And what it will do is it will create some coverage in the statutes that will allow local law enforcement to step in and deal with people who are interfering with the federal law enforcement officers. Under current law, the definition of law enforcement officer in the Kansas statute generally does not cover federal officers. It's only state and local officers. And so the advantage to this is that if we have a situation like what's happening up in Minnesota, for example, and you have people interfering with federal officers, then local officers can step in and deal with those people creating that interference because it's now covered under state law. Well, we allow the federal officers to deal with the business they are dealing with that we can't perform. And that's the whole concept behind this bill, is to just give us these tools to address issues like that. So Section 1 of the bill is the safety zone bill. This is something that's been going on in several states. It's been brought up in Kansas to us several times, wanting us to pursue one of these bills. We've been kind of watching the case law on it in other states. And this particular provision was fashioned in a combination with law that is in Florida that has not been overturned, and a law in Indiana. And Indiana's initial law was overturned by the courts. And then in 2025, Indiana amended their law following the court decisions and fixing the shortfalls of their law. So the way this would work is it's very careful to carve out specific reasons that would justify having people back 25 foot. An officer can't just willy-nilly say, I just don't want anybody within 25 foot of me. That won't work, because this law requires there to be some reasonable belief that circumstances exist that is distracting the officer from their duties in dealing with whatever they're dealing with, or that there's an increased level of concern over any person or property from injury or damage. And once that is achieved, if an officer has that reasonable belief, they don't have to, but they can order everybody back this 25 foot. And there's no violation until such an order is given and such an order is violated. So it's not that there's this magic 25 foot everywhere we go. It has to be a reason that we declare people stay back. And sometimes that's when we're engaging in a suspect in a violent crime or something like that, and we have people coming up on top of us and kind of yelling at us and distracting us, but not really physically interfering with us. If they physically interfere, then we've got laws to cover that aspect for local officers. And this would also include the federal officers in this. However, federal officers could not enforce this. Only local and state officers would be able to enforce this. The revisor went through the other sections of the bill. I'll just hit them real briefly. Section 2 of the bill is that abandoned vehicle interfering with law enforcement operations. This is an issue that happens sometimes. People will park vehicles intentionally and abandon them where it's blocking entrances to parking lots and things like that, where the federal agents are trying to work. Section 3 includes the federal law enforcement vehicles, and it, along with Section 4, the revisor described what that does. It makes it clear that the county commissioners do not have to authorize emergency vehicles. So in current law, certain types of emergency vehicles, fire vehicles, police vehicles, ambulances, are automatically, under state law, emergency vehicles. Any other vehicle can become an emergency vehicle if the Board of County Commissioners declare it so. Some examples of that would be some counties, they make their emergency management vehicles emergency vehicles. In some of your rural areas, wreckers can be declared emergency vehicles. That's because they are the ones with the equipment to extricate people from a crash and things like that. So it's just a clarification on that. Section 5 is the interference of a law enforcement officer, which I touched on briefly in my opening remarks. And what it does is it adds federal law enforcement officers to those who can be the victim of interference with a law enforcement officer, so we can take those enforcement actions. And then Section 6, we already have a law in the book about interfering with conduct of public business in public buildings, but right now that only applies to state and local government buildings. It doesn't apply to federal buildings, and so it would with this revision. And then Section 7 was that addition of the federal law and executive order under the, I believe that's the Kansas Tort Claims Act is what this is in. Reviser can correct me if I'm wrong. So what this bill does, it gives state and local law enforcement authority to assist federal law enforcement partners through enforcement of violations being committed against the federal law enforcement officers that currently aren't covered under statutes. It removes the barrier we face under current law because federal law enforcement officers, federal buildings, not included under statutes, even though in most cases those violations would be a federal violation, we cannot arrest for a federal law violation. We have no authority to do that. And so this bill does nothing to change what our authority is in making arrests, doesn't change anything in the authority of federal officers in making arrests on state law. So with that, I would be happy to answer questions.
Committee, any questions for Ed? Representative Rees.
Thank you, Mr. Chairman. Ed, thanks for your presentation. So an example, if we have a situation on the streets and both entities, federal and local, are there, who maintains jurisdiction?
Well, both of us have certain levels of jurisdiction. So we would have jurisdiction over any state law or local law that we have jurisdiction over. The federal government would have jurisdiction over federal laws, but we do not have jurisdiction over federal laws unless we're into some kind of an agreement where we've been deputized by them, which this bill has nothing to do with that process.
One more question, Mr. Chair, real quickly. So what I'm understanding is that the control of the scene just depends on what law is being violated. Is that my understanding?
Well, the enforcement would. The control of the scene, we're going to work together on that in most cases in trying to control that. I think the federal government's going to be fairly limited to that control right around the immediate area of where they're acting. And our role may be broader than that, depending on how far out whatever actions are being taken to disrupt the function of the law enforcement is what that scope is. So it just kind of depends on the situation. But we each have our defined jurisdictions. But when it comes down to when disturbances are happening and maybe vandalism's occurring or things like that, then we're all going to be working together on that. And part of the focus of this bill is to allow us to take care of what we can take care of so the feds can take care of what feds take care of.
Thank you, Ed. Thank you, Mr. Chair.
Representative Smoy.
Thank you, Mr. Chair. Ed, good to see you. I'm just wondering, because of the halo part, the 25 feet, clearly this is going to be used in situations of high stress to where they feel like they need to implement this. I'm just wanting to make sure that everybody understands in those kinds of scenarios, what does that look like? What determines, like, what are the thought process that they are using to implement this 25-foot, and who determines if that was appropriate to do at the time?
Okay, so what the statute would provide is that the officer would have to have a reason to believe, which is a standard that's generally used across criminal law and applications we do. Like when we make a Terry stop, when we stop a person we suspect of illegal activity, we have to have a reason to believe they are committing, have committed, or about to commit a crime. So it's the same kind of principle. Our belief has to be reasonable. It can't be unreasonable. And once we reach that and we have that belief, reasonable belief that I need to do this to preserve the safety of myself, the people I'm dealing with, or others, or their property, or that they're distracting me enough that because of what they're yelling and everything, that we just need them to get back and give us some space, then they could declare that. You have to relay that clearly, that you're now declaring that and you need to stay back or you need to leave that 25 foot. And then the violation doesn't occur until somebody comes back into it in violation of that order or comes into it knowing that we've given that order. And typically what's going to happen is somebody comes into it, we're going to warn them again, stay back.
And if for some reason somebody feels like that was unnecessary at the time and it goes all the way through, the courts will determine at that time whether that was reasonable, correct?
We would have to articulate to the courts that our belief was reasonable and the action was necessary, and if not, the case would be dismissed.
Thank you very much.
Representative Howell. Go ahead.
Thank you, Mr. Chairman. So can you clarify to me, Mr. Klump, would this apply to a state law enforcement agency, KBI, say they're doing an investigation, there happened to be a scene where people were encroaching, does that apply to them too, or only when federal law enforcement?
Are you talking about the 25-foot rule?
Yes.
It would apply to all law enforcement, including state, local, and federal.
Thank you for clarifying that. And also, I don't believe there's any mention about National Guard soldiers. You know, I'm thinking of like, say there's a natural disaster and sometimes people come up on the scene that aren't, you know, part of that community or something like that, and maybe that causes a concern of some sort. Do they have any authority under this bill?
There is a small section of National Guard and Reserve that are law enforcement officers that are included in one or two of several definitions of law enforcement officers. So it would depend on what their function was at the time, which definition is applying. Then some of them, and those are generally your military police officers that we're talking about, or in the case of Forbes, the Air Force police. And other than that, though, it generally wouldn't include them in these laws. There's other laws that when they get activated in crowd control, they would have authority, but it wouldn't be under these laws.
Mike, did you have something to add to that?
The definition of first responder, the focus has been on law enforcement, but it also covers emergency medical services and firefighters, so it's beyond just law enforcement.
Good point. Thank you.
Representative Mosley. Representative Haskins.
Thank you, Mr. Chair. Mike, this is, before I ask the conferee the question, is under the definition of law enforcement officer, am I reading this right, or is this already in existence that it now includes any federal law enforcement officer? Is that a new definition of law enforcement officer?
There's a two-part to the definition, and one is state law enforcement officers as defined under the Kansas Criminal Code, which is 215111, and the other is any federal law enforcement officer, so that is new for this bill. And it, as defined in 5 U.S. Code Section 8401 or 6 U.S. Code 271 and 5 U.S. Code 8401 is a very broad definition of who is a federal law enforcement officer.
Thank you, Mike. So, Mr. Klump, thank you again for your testimony. And so that brings my concern about this policy, and maybe you would like to respond on it. The page 1, lines 31 to 34, a first responder means a law enforcement officer. And then we define a law enforcement officer, and now it includes a federal officer. So to me, the one can make the case, and I'm not an attorney, that we don't need state or local to enforce this because we define them as a law enforcement officer at the federal level. It seems like this is a bad policy if we move forward. Could you respond to that?
Sure, I'll be glad to. So by adding them to the definition of law enforcement officer, and you'll notice that it's specific to this statute. So when we add the federal law enforcement officer, starting down on page 1, line 35, it means the same as in 215111. That's the definition that globally covers the entire criminal code. And we didn't want to do that broad, because then they get enforcement authority. But by doing it the way we do, the way I understand it, it adds them to the definition of law enforcement officer for the purpose of this statute, not any other statute, and allows them to give this order, but it doesn't give them any arrest authority the way we see it anyway. I don't understand it to giving them arrest authority.
Representative Wagner.
Thank you, Mr. Chairman. Thank you, Mr. Klump. The situation, I mean, occasionally you will have cases where people, I mean, it's kind of like more of like a public protest. They're protesting the policy or something. I mean, does that, how would that interact with that if the person's intent is more protesting the overall policy in just sort of a First Amendment way? It still, does that interact with this, or how would that interact?
Well, certainly exercising your First Amendment rights does interact with this. I mean, clearly it does. And there's significant case law on that that would not come into play to allow us to designate a 25-foot area just simply because they're in there demonstrating. They would have to be doing some conduct that would cause that level of concern that they're interfering with our ability to conduct our business, or they're interfering with the protection of property or a person from injury. So a simple demonstration would never stand up as a reasonable grounds to do this in and of itself under the case law that's well established in both federal and state courts.
If I can, Mr. Chairman. I mean, but it seems kind of a low threshold of be distracted from performing such first responders' duties. I mean, being distracted, you know, a bunch of people yelling, you know, 20 feet away, you know, I don't know. I mean, does that play into it?
So generally the situations like we're talking about, and it, you know, it's hard to define them concretely without getting too narrow, but generally what's involved is we're confronting a person that is disruptive, they're maybe resisting us, maybe it's somebody who's wanted on a dangerous felony that we're trying to take into custody, and people are coming up and trying to yell and scream at us, and they're right on our backs, and we're worried about our safety and sometimes even the safety of the person. I mean, take, for example, a domestic violence situation. Sometimes the other party is there trying to get to the person that we're trying to take into custody. And so it's that kind of situation we're really looking at most of the time that this is going to take place. But clearly, the intent is, and we don't think it would be ruled by the court to be a reasonable belief of either of those two conditions that are required, simply because somebody is protesting, you know, and not conducting themselves in a way that causes one of these other two things to happen.
All right. Yeah, thank you.
Representative Myers.
Thank you, Mr. Chair, and thank you for being here, Ed. So I have some concerns with this. It seems like this is giving a lot of authority to federal law enforcement officers, and I know you just mentioned instances of domestic violence and, you know, felony warrants and things of that nature. But that to me sounds like that would be more of a local law enforcement issue, not a federal law enforcement issue. Can you explain why you use those examples in response to the previous representative's question?
Well, the thought was that if it's a federal law enforcement officer engaging in their business and this interference has taken place, it gives us a tool to then interact with those people and get them back out of the 25-foot area and stuff. And again, just like the rest of the bill, it's designed to give us tools to deal with what we can deal with so they can do the business that we can't deal with federal law. Most of these things would be a violation, not the 25-foot rule, but the rest of it would all be violations under federal law with interfering with the federal agencies and stuff. But that's not something we can enforce, and then that takes them away from doing the business they need to do, whether it be ATF, FBI, DEA, ICE, whoever.
Follow up? Okay, so with that noted, my main concern here is not so much with the federal agencies like the FBI and the DEA, who have well-trained agents who are very experienced working within the communities and with local law enforcement, but rather with immigration agents who, as I think we've heard, have very little training. Can you tell me a little bit about the training that most ICE officers receive?
I have no direct knowledge of the level of training they're receiving, especially right now under, the hiring that they're doing. I would just state that in our involvement with this bill, as we were working with the people that brought the bill, it was very important to us not to expand any authority to the federal officers as far as making an arrest goes. The arrest of state laws needs to remain with us, not with the federal agencies. And there's very few exceptions to that.
I think where I'm going with this, and this is both a statement and a question, but from what we've seen across the country with demonstrations against federal ICE officers, there has been a lot of I don't really want to denigrate them too much, but it seems like they take a broad idea of what interfering with their actions may be. So, it's very important for individuals to be able to record and observe the actions being committed by federal officers. And I'm concerned that with a bill of this nature, this could expand their authority in a way that could eliminate their ability to exercise their First Amendment rights, as well as make sure that we're protecting the public. Can you explain how this would not do that?
Well, first of all, no statute, no bill we pass, no statute we create can override the First Amendment rights of people that have been established. And so we have case law, for example, you mentioned photographing and videotaping. We have case law on that right now that in and of itself cannot constitute any kind of interference to the officers. There is a First Amendment right well established in the federal courts, especially the appellate courts, including our own 10th Circuit, that clearly states to law enforcement, people have a right to videotape you while you're performing your duty. What they don't have a right to do is get in a position in doing that interferes with you doing your work. And so this kind of fits in with what those case laws have said. And law enforcement in Kansas, maybe ICE doesn't get this yet, I don't know, but I can speak for Kansas law enforcement, understands that is a First Amendment right. And it's not a violation of this statute just to be within 25 foot, unless you're told to get out of it. And like I said, to get out of it, you have to establish reason to believe it's necessary.
Representative Mosley.
Thank you, Mr. Chairman, and my colleague asked a lot of the questions that I have had, but can you give me an example, a Kansas example of what made this bill necessary? Because like right now, you're kind of giving like hypotheticals, like, oh, it could be a domestic violence. Don't see why ICE would be there. Don't see why in a regular situation, ATF would be at a domestic violence situation down the street from me. But this is giving a lot of authority to federal agents in a way that makes me very concerned. So can you give me an example of in Kansas why something like this is necessary?
Well, fortunately, we haven't had the ICE demonstrations in Kansas like we've had in other states. And I think this was an effort by the people that brought the bill to give us those tools to deal with these situations if they did start happening here. But certainly I can give you lots of examples in my own experience of situations where to create that 25 foot would have been very advantageous to us from our own safety and able to concentrate on taking care of situations at hand without that interference going on.
So you don't have a specific Kansas example. And so my other question is, if I may, Mr. Chairman, you keep saying the people who brought this bill up. Who are those people?
This bill was requested by Senator Masterson, and he reached out to us. We worked in conjunction with him on developing the bill.
One more question, if I may. Did you guys consult any experts? I don't know if Senator Masterson is an expert on law enforcement or the First Amendment or any other thing.
I don't know who else they consulted with.
Representative Howe.
Thank you, Chair. I have several questions. Some of them may be for the reviser also, if I may. One is currently, under our current laws, one may be more of a policy. Are federal law enforcement officers obligated to notify local Kansas officers of their presence and upcoming actions within our state borders?
Nothing that I know of is a requirement to do that.
Okay. And then my next question would be, currently, are federal law enforcement officers allowed to implement something like the 25-foot rule themselves right now if they were implementing anything within our borders right now, our state borders, as they were doing their business here?
So if they are allowed to do that, and I don't know if they are or not, they would have to do it under federal law. And I'm not that familiar with the federal law for each one of them to know. I'm not aware of them having a 25-foot rule per se like this one is, but they certainly have interference laws that I don't know if they're the same as ours, broader than ours, or how they apply.
If I may, Chair, does Mike know the answer to that question?
Go ahead.
I'm not familiar with the federal law, and I don't know if there's anything comparable to this. We can find out, but off the top of my head, I can't answer it.
Okay, thank you. And then if I may, could I do one more? This bill is expanding the definition of law enforcement to EMS and firefighters. And I was just wondering, I know you're really good under normal circumstances. I know it's your normal habit to confer with other organizations and speak with them. And I'm just wondering, have you had an opportunity to speak with the EMS and firefighter organizations and talk to them? I haven't had an opportunity to look through all the testimony today yet. Have they had an opportunity to weigh in? Do they have any concerns or anticipate any unintended consequences with this? I know that firefighters and EMS, for example, really enjoy a lot of trust from the public that law enforcement doesn't always get to enjoy. And I'm just wondering about that.
I have not personally communicated with either one of them. Like I said, we didn't create the bill, and if I were creating the bill, I probably would have done that. I know our association always tries to include them in things that we think would be helpful to them, but we do it by conferring with them when we create bills. But in this bill, I have not personally communicated with them about it at all.
Ed, thank you for coming. I don't see any more testimony down here. Thank you for your presentation. Committee, that's all I had on the proponent side of that. We are going to go ahead and open up the opponent side of this, and looks like I have 1, 2, 3, 4, 5, 6. Looks like we have about 8 people wanting to speak. So if we could kind of keep it wrapped up and keep on point a little bit, we'll ask questions at the end. First up is going to be Dioselin Tott.
Thank you, everybody. Thank you, Chairman. I'm online.
We can hear you, and welcome to committee.
Okay, awesome. Thank you. Again, thank you,
That
Chair
down there.
Kessler, members. Yeah,
What's that?
are we, just wanting to see if we're
You're-
good to go?
Yeah, we can hear you. You're good to go. Welcome to
All
committee.
right, thank you so much. Again, thank you, Chair Kessler, members of committee for this time. My name is Theoslin Tot. I am a resident of Wyandotte County, a homeowner and someone who works closely with families and communities across Kansas through my work in Latino Community Network. Thank you for the opportunity to testify today in opposition of SB 452. I just want to start with something simple. Kansas care about safety, accountability, and fairness under the law. SB 452 moves us away from those values. This bill gives federal immigration agents expanded authority inside our communities while also shielding them from accountability under the Kansas law. It grants protection similar to those given to trained Kansas law enforcement officers who have done it for years. Yet many of these federal agents receive significantly less training and they're the one giving orders. At a time when federal immigration enforcement is expanding rapidly, training for new agents has been reduced roughly to 6 weeks. In the contracts, Kansas law enforcement officers train for months before entering the field. That difference matters when people's safety and constitutional rights are on the line. And I also want to be clear about something. This is not only about immigration issues, because this is a risk for all Kansas, regardless of their status. SB 452 also raises serious concerns about the Fourth Amendment, the constitutional protection against unreasonable searches and seizures, just because of reasonable doubt. Depending if they're well trained, across the country, we are already seeing reports of aggressive enforcement actions, including door-to-door operations that raise serious constitutional questions. Expanding authority while simultaneously expanding immunity sends the message that constitutional protections are optional, and they are not. Another major concern is bill bakes language around interference. The bill creates criminal penalties for interfering with federal immigration enforcement activities, but it does not clearly define what interference means. So I have to ask the practical question that has been asked already: how are Kansas supposed to know when they are interfering? We have already seen immigration enforcement carrying out using unmarked vehicles and our agents who are not clearly identifiable. News outlets have reported on these incidents. These are not rumors or social media claims. If enforcement action occurs with unmarked vehicles or unclear identification, how are ordinary people supposed to know they must yield, move over, or stay away 25 feet? Are Kansans now expected to recognize unmarked vehicles and assume federal enforcement is taking place? That confusion creates real risk. People could find themselves in the wrong place at the wrong time and suddenly face criminal charges for something they did not even know was happening. The bill also allows detentions through a 48-hour hold connected to these enforcement actions. These raises concerns about the due process and the potential for individuals, including U.S. citizens, to be detained without clear justification. I also want to address the way people are being labeled in these conversations. In these buildings, I have heard legislators talk about family members who were once undocumented or neighbors who work hard and contribute to their communities. Yet in the same conversation, those same people are described as criminals simply because of their immigration status. I recently had a conversation with a police officer that struck me as well. Our discussion was along the lines everyone must confront their mistakes, even police officers. He explained that officers sometimes come from difficult past, but if they take responsibility, change, and go through the process, they can still earn the opportunity to serve as officers. That conversation reinforced something important to me. One mistake does not define the entirety of a person's life. It also reminded me of something we were all taught growing up in this country, that people are innocent until proven guilty, not guilty until proven innocent. Yet the way immigration enforcement is being expanded right now flips that principle on its head. People can now be detained, questioned, or caught up in enforcement operations simply for being present in the wrong place at the wrong time, or for the examples given, leaving their car at the wrong place at the wrong time. Meanwhile, mean Kansas are asking a very real question. Why are we creating more laws that target vulnerable communities when there are already serious issues that really deserve our attention? Fraud, exploitation, and those who are public systems often go unaddressed, while enforcement continues to focus on people who are working, raising families, and contributing to our neighborhoods. As a taxpayer and a homeowner in Kansas, I want my tax dollars going towards strengthening our communities, funding schools, supporting housing solutions, helping address homelessness, which is things that we desperately need. I want resources invested in the things that actually improve public safety and stability. Policies that expand unchecked enforcement power while reducing accountability to the opposite, they create fear and confusion and division. So Kansas has long valued accountability in government and respect for constitutional protections. Authority should always be matched with responsibility. None of us get to do our work without it. We all have to be responsible. We all have to have due diligence. SB 452 expands authority while weakening safeguards that protect Kansans. For these reasons, I respectfully urge the committee to vote no on SB 452. So thank you for your time and your consideration.
Thank you, Dicelyn. And we'll take questions at the end here. Next up, we have Ellen Johnson. Ellen, are you with us? Just as a reminder, we have, like I said, we have 7 more people that want to speak, so we're going to have to kind of keep it on point a little bit. But Ellen, welcome to committee.
I haven't really been hearing anybody my entire life complain that federal law enforcement just can't do their jobs and they need, you know, special immunity and extra help. And I really don't like it with the thought that local police need to do their jobs. I would rather that federal law enforcement take care of themselves. And I have no problem in absolutely believing and assist where it's necessary. And I did not believe that that was in any way prohibited by present law. I mean, I am going to say this. One thing that was particularly concerning as I was reading the written testimony of our law enforcement proponents is that the execution of federal law also includes executive orders. Are these presidential executive orders that we need help with, and that our law enforcement, federal law enforcement needs special immunity for? A lot of those are illegal. I like law and order. I like rules. And I don't believe that we should start doing other people's jobs and pay for it ourselves. I don't believe that any law enforcement actually needs qualified immunity. I believe that they should be held to the same standards of behavior and accountability as myself, even in a life-threatening situation. My life matters just as much. And I see champions for justice here all day long, parading around, telling everyone that they're standing up for victims by relaxing the rules of evidence, by making it easier to put people in prison and jail. And I want to say, if we need that kind of accountability for criminals, why don't we need that kind of accountability for criminals? Sometimes they're cops. People need to be accountable for their actions. And I want to remind you something else. No state official controls federal law enforcement. So I don't want the burden of helping federal police take orders to rest on our local and state police, especially enforcing our president's executive orders. Did I read that correctly? I want to tell you something. If you think that this is going to help and that you're immune because you are law-abiding, I'm not scared I'm going to get arrested. I do everything I can to be a law-abiding citizen every single day because in my day-to-day life, I represent people who fear very violent retaliation. They're scared their family members will be killed. So I have to follow the law and stay out of jail. I'm not going to jaywalk, okay? I'm not worried about myself getting arrested protesting in the least. But my mother was arrested by Border Patrol last year. My 73-year-old white Anglo-Saxon Protestant mother was arrested and handcuffed by Border Patrol and interrogated for hours like a criminal. She was a special education teacher at the children's prison. My father is an Air Force veteran. Our neighbors are police and lawmakers. And that didn't matter. She wound up in handcuffs. Her apple pies win prizes. It's gonna be your 73-year-old mother in handcuffs. This stuff isn't making the news. We do not need to help these guys not do their jobs. We don't. They need accountability. We should not be involved in any way And I mean, I just don't support this law. It sounds like the creation of a dual state, and it also sounds like a huge off. We know we're about to be flooded with ICE agents and federal agents now that this prison is opened up. So this is definitely going to draw down our resources. I know I'm the run to the fire type, so I understand why this highway patrolman really, really wants to help. I get it. I think that was poorly thought out. Thank you.
Thank you, Ellen. Next up, Rick, is it Berens? Sorry for getting that wrong if I am wrong.
It's close. You're close.
Welcome to
Good morning.
committee.
Thank you for hearing my testimony. It's Rick Behrens. I think it's become clear that this bill is mostly about federal overreach, mostly about ICE and expanding their authority, and in a very scary way, I think it blurs the lines between federal authority and our local authority when it comes to law enforcement. I'm testifying on behalf of Kansas Interfaith Action. I'm a pastor of a small but mighty little boat of Jesus followers in Kansas City, Kansas. We're a 136-year-old congregation that has been bilingual and multicultural for the last 25 years. January marked 1 year since we moved out of our sanctuary and into a locked basement for safety. It's ironic and shameful, is it not, that the safe places called sanctuaries are no longer safe places? We moved underground to protect ourselves after the president issued an executive order declaring churches, schools, daycares, and hospitals open hunting ground for what we have learned and seen as an unregulated and undertrained group called ICE, for them to arrest, abuse, and even murder should they see fit. We have locked ourselves into our basement every one of the last 60 Sundays, abandoning our sanctuary to huddle together for prayer and worship in a locked room for fear of our own government, for fear of masked men. Despite this unmerited fear, we continue to serve the community and celebrate who we are as the multicultural, diverse body of Christ. Moving underground has allowed our little boat to stay afloat, helping everyone to feel and be safe for an hour or two on Sunday mornings. But the recent memo encouraging ICE to flaunt the Constitution and enter homes without warrants is troubling, to say the very least. Our scripture tells us that when immigrants live in your land with you, you must not cheat them. Any immigrant who lives with you must be treated as if they are one of your citizens. You must love them as yourself. Jesus told us that he is the stranger in our midst, and anytime we do not welcome a stranger, we do not welcome him. And in Hebrews, we are told to welcome strangers because in so doing, we are entertaining angels. What ICE is doing today, what our federal government is doing today, goes against Christian ethics and values, goes against the values of every religion, and violates the values that we hold dear as Kansans. Our neighbors are good people, working hard to make lives for themselves and their families. They do not deserve to be hunted, kidnapped off the street, pulled from cars, beaten, pulled from their homes without warrants, separated from their families and communities that love them and need them. ICE does not deserve to be treated like local law enforcement. In fact, the equating of ICE with local law enforcement will make our communities less safe, as our neighbors will be afraid to report crime and to testify as victims. In fact, the equating of ICE, the more license they are giving to do what they have been doing by equating them with local law enforcement, the more we will all live in fear, and the less safe and productive we will be as Kansans. We are no longer living in a free society when we are forced to huddle in church basements with doors locked. This is not who we are as Kansans, as Midwesterners, as people of faith, as Americans. Your faith in your community, your belief in common decency should be enough to say no to this bill. So please do so. I pray that you will please say no to this bill, which will not make any of us any safer. Thank you.
Thank you, Rick. Next up, we have Emily Emery. Emily, are you with us? we'll move over that one and come back and see if, I did have a name on there and it was scratched out with another name wrote above it, so I wanted to, I have two Emilys on here, so, but I'll come back to that again. Next up is Sean Lowenstein. Is Sean with us? Okay. We'll move that for sure over into written only. And our next Emily is up, Emily Bradbury. Emily, welcome to committee.
Thank you very much for allowing me to weigh in on Senate Bill 452. Chairman and members of the committee, thank you for the opportunity to speak today. On behalf of the Kansas Press Association, our 160 publication members, and our colleagues in broadcast media, we strongly oppose Senate Bill 452. It gives police officers and other first responders broad, subjective power to decide who can stand nearby and even to charge peaceful onlookers potentially with a crime. We believe that Senate Bill 452 is a serious threat to the First Amendment rights and to Kansas taxpayers who could end up footing the bill for lawsuits. This bill does not set neutral time, place, and manner rules for the First Amendment. It leaves everything up to the judgment of the officer in the moment. Only the officer decides what's necessary for safety, what counts as a distraction, and even when someone has been told not to approach, there are no clear, objective standards in this bill. If passed, Senate Bill 452 would almost certainly lead to constitutional violations and civil rights lawsuits under federal law. Officers who arrest someone lawfully observing cannot claim qualified immunity. That's a costly outcome for both law enforcement and for taxpayers. We are also deeply concerned that there has been no evidence showing that a 25-foot buffer is needed to protect public safety in Kansas. Journalists are often within that range while covering events and are often on scene before a perimeter is established. For them and the public's right to know, distance matters. A one-size-fits-all buffer like this would make meaningful coverage impossible. And finally, Kansas already has laws against interfering with or assaulting officers, and they work. For those reasons, we respectfully urge you to vote no on Senate Bill 452. Thank you.
Thank you for your testimony, Emily.
Thank you.
Next up on WebEx, we have Alejandro Rengo Lopez. Are you with us?
Howdy. Yes, good morning, Chair Kessler, members of the committee.
Welcome back to committee.
Thank you. Thank you so much for the opportunity to provide testimony today. My name is Alejandro Rangel Lopez. I'm coming to you today virtually from Dodge City, and I'm the campaign manager for New Frontiers, a project of Loud Light Civic Action. I'm going to keep it short. I don't have anything to say that the other conferees that went before me haven't already said. The only thing I want to add, right, is that Kansans don't want this body to give federal agents even more power at a time when there are countless examples of the very same agents brutalizing U.S. citizens. We can't separate this bill from the context it arose under. I ask, why now? Why do we suddenly have to grant these protections to federal agents, right? It isn't, new that local law enforcement and sheriffs have to, work with ATF or other federal agencies to collaborate or, help on, certain operations, right? But why now? That's my question, right? So I say to you, right, SB 452 should be opposed not just because it's an attack on our ability to limit federal overreach, but because it invites misconduct, abuse, and violations of human dignity, right? Kansans like their government small and the protections we have against overreach. This bill serves neither of those values, right? So I encourage you to vote to oppose SB 452 and defend the right of Kansans to hold those in power accountable. Thank you, and I'm available for questions at the appropriate time.
Thank you, Alejandro. Next up, also on WebEx, we have Dakota Britton. Dakota, are you with us? Nope, he is not on. That actually and it takes up my list here. Did I miss somebody out in the audience that was expecting to speak and I didn't call your name? Not seeing any there. Committee, we'll go ahead and open up for questions. Do we have any questions? Representative Smoy.
Thank you, Chairman. This question is for Emily Bradbury. Thank you, Emily. You made a statement that this would make meaningful coverage impossible. Can you give me an example of that?
Sure. What our concerns are from our members are that sometimes they are even sometimes one of the first people on the scene. We've heard statements saying we try to help first responders if they're there, especially in our smallest communities. There are really good relationships happening, that they are able to help them get the public back or be able to help them with the public. And so meaningful coverage from 25 feet, we feel like that is just a very arbitrary number. And depending on the situation, it's going to depend on how the situation is and how it's working. But having a set just arbitrary 25-foot barrier does not help with coverage. And we're afraid that that could meaningfully impact our First Amendment right for the press.
Would there be a range of feet that you guys would feel was more appropriate than 25?
I think just that is just going to, we just don't like that arbitrary number, period, like having a number. Like there's already laws that exist that prevent us from interfering with law enforcement, and those laws do work, we feel like. And so having that 25-foot barrier is just it's just not going to apply to every single situation.
Thank you.
Just kind of expand on that. You don't like the arbitrary number, so wouldn't that be better than just letting the officers cite you for that based off of whether they thought 6 foot was too close or 8 foot was too close or 10 foot was too close or 15 foot was too close? Doesn't this kind of set some perimeter, some guidelines to that? Versus not having a hard number anywhere.
Sure. Well, I think right now when our reporters are told to step back, they step back. They are told to get back. So our concern is to have that arbitrary number of 25 feet. It is, first of all, who's going to measure that? What if someone is reporting and that law enforcement officer, they're set up, ready to go, and that law enforcement officer determines that that is within, it's too close and making them move? That is our concern, is that it's going to eventually be used to push people back enough to where they're not going to be able to report on scene. So as far as having a number, no, we would not like a number, correct?
So 2 feet would be fine. I mean, no number one. Okay, I got you.
Yeah.
I'm just thinking of a dire situation where a medical emergency, who knows what, and you got a crowd of people in there. You just need to back everybody up so the medical team can get in and do their thing and kind of have some room. And if the first responders that were there asked people to back up and they didn't back up, now what do we do? I mean, I don't know. I'm just thinking of all different scenarios. I was going back through some of the testimony, and it just, throughout the entire testimony, was nothing but ice, 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 ice. I don't think the bill actually really directly talks about ice in here, but I get the correlation. But when we're talking the circle of, I just think of having a hard number somewhere that gives everybody kind of an idea of where they need to be. If we say get back and they don't get back, I don't know, it's just, I'm kind of frustrated with it just a little bit, but I appreciate it. Thank you. Committee, any more questions? Representative Sanders.
Thank you, Mr. Chairman. So what's your experience with reporters interacting with law enforcement in an active scene? Are there generally issues, or is there generally cooperation?
There's generally cooperation, and that's just another piece of why we have an issue with this bill. There are laws in place. A majority of our publications, they're sometimes one of the first people on the scene, especially in our rural areas. Like I said, I heard from a publisher last week that she helped a sheriff's officer secure the scene because she was the second person there on scene of a wreck. And so she was actually able to be helpful. So my issue is this bill also, in my opinion, creates a solution for a problem that does not exist here in Kansas.
So is your fear that this will be just randomly enforced?
Correct, yes, correct. There are already laws in place that prevent interfering with law enforcement. And unfortunately, any bill that helps try to expand that is rife for abuse, absolutely.
Thank you, Mr. Chair.
Representative Lewis.
Thank you, Mr. Chair. Well, one of the fundamental principles of criminal law is that you have to give notice to the people as to what is criminal and what isn't. And consequently, if we don't have a 25 feet rule, it leaves it completely open and vague, and I think it would violate that principle. What do you say to that?
I say that this bill, first of all, doesn't create what actually a distraction would be, what it means to have for fear of their life. And also for a 25-foot, it's not required that they implement this. It is completely arbitrary to what officer is on the scene, just like the previous conferee talked about how it can just be implemented if that officer deems it should be implemented.
Committee, any other questions? Not seeing any. Thank you for your testimony. Committee, not seeing any more questions. We're going to go ahead and point out we do have several written testimonies available in your S drives. And with that, we're going to close the hearing on SB 452. That actually wraps us up today. Tomorrow, we have another hearing tomorrow, and you can expect to work some of the bills that we've already been hearing. We're going to go ahead and probably tee some of those up to do final action on tomorrow. So does anybody have any questions for the committee? See you none. Thank you guys, and we're adjourned.